Welcome to the Star Chamber. I'm Ryan Swayze, a retired Air Force Lieutenant Colonel and the founder and president of the Walk the Talk Foundation, a nonprofit that advocates for and advises currently serving and former military service members going through the arduous journey of administrative processes and investigations in our government.
And I am Francesca Graham, a retired Army Lieutenant Colonel and the Chief Operating Officer and Chief Advisor for the Walk the Talk Foundation. For all our returning guests, welcome back. And for our new listeners, thank you for tuning in. Before we begin this week's topic, please do not forget to hit that subscribe button, check out our Walk the Talk Foundation website, and hit that donate button if you think we're doing a good job. Also, check out our newsletter, the DoD Times Redacted, on all the socials, including LinkedIn, X, Instagram, and Facebook. Links in the description. All right, Star Chamber listeners, let's get started.
So, Cheska, what are we going to talk about this week?
Well, this week we are going to talk about a topic that us here at the Foundation, we love to talk to our clients about. The relevance of evidence.
Oh, I love it already.
Yeah. So typically when we are speaking with either a client or someone that we're just doing an initial consult with, or someone who just wants to chat, a normal thing that we hear is, well, I have 3 binders of evidence, or I can send you all the documents related to my case, and could you just look over these 300 or so pages real quick and let us know.
Real quick,
And let us know what you think about it. And there's some trends that we've noticed over the last 6 or 7 months of my time, a little over 3 years of your time.
True.
With the foundation. So really with this podcast, we want to talk about those trends, as well as give our listeners, our loyal listeners, all 400 at least of you out there today,
At a minimum,
some ideas for how to build your case.
Love it.
And I think that's the first thing I would like to talk about is the trends. So Ryan, given, you've obviously been doing this quite a bit longer than I have. You've been here about 3 years as president, founder of the organization. So what are some major trends that you've noticed as you've spoken with service members, active, former federal civilians regarding evidence?
I think the first trend, which trips people up and really submarines their cases right out the get-go, is what you alluded to at the top of the show, which is this inundation of information. And I see it in the documents. I see it / hear it when I speak to potential clients as they recount the sequence of events. It's just too much. And you have to understand your audience when you're presenting a case or complaint, whether it be a congressional staffer, whether it be an inspector general, or an investigator. They have limited time. They have limited attention span. They're human. And to overwhelm them and or distract them from the salient points of the case works against your case from the outset. And that's what really I think is trip up number 1, is whittling it down to the germane facts, events, documents, what have you, of the case. Everyone we talk to, without exception, says, my case is complicated. And they're half right.
Yep, always.
Because I can take any case and whittle it down to basically a page of bullets, because there are, especially as it relates to reprisal, restriction, retaliation, there are key elements to proving that. And there's only 4. So I can boil down everyone's case into 4 bullet points. And if those are fulfilled, they've got a case. Everything else around that is just peripheral / distracting. Trend two is expecting the inspector general to do the job of the complainant. It is
Mm,
not an IG's role or responsibility to sit there and listen to your story for 6 hours or whatever it is, and to find the regulatory violations of law. That's on the complainant. In fact, I think most services have a complaint form that asks explicitly what rules, regulations, laws were violated. A lot of times when we're doing initial intakes, the clients have not thought through that, and or they've already filed a complaint and they have not enumerated any rules violations, or they've missed key ones. You and I are working on a case right now where the complaints had been forwarded, and there were rules violations listed, but the overarching reprisal was not even filed as a complaint, and
yeah.
that was a huge misstep. And you know which one we're talking about there, and that's a common trend we see is they fire the 300 pages of documents, three binders, etc.,
Hmm.
and they expect the IG to pick through that and find where there were doings of wrong, and that's just not how it works.
Well, and I think it's kind of a funny tying to that. You had sent me yesterday or a couple days ago Army Regulation 20-1,
Mm.
and you had highlighted in there specific language specific in Army Regulation 20-1, which talks about the role of IGs inside of the Army. And it specifically says in there that the IG is works for the commander and works for the organization. I mean, specifically says
Yes,
the
only,
IG.
I think it even says only for the commander.
Right, exactly. And so if
Wowzers.
right, and so if you're a
But we're
complaint,
independent. We are
right.
independent, just
Well, there's
remember.
there's that too. But if you're the complainant to Ryan's point, and you're expecting this person who works for the command to then find the violations of law, policy, regulation that the command has violated on your behalf, it's just not, and that's just not for the Army. I mean, that role of the IG is consistent across the services. But
Yeah.
yeah, so they are not going to expend that energy, number one, because it's not actually their role, and number two, because then they would be working against their own performance evaluation.
Yeah, we're dabbling on issues from former episodes now for sure, but yeah, exactly correct. And I think the third trend is expectation management as a
Mhm.
general sense. Pertains to inspectors general as well as Congress, staffers, caseworkers, etc. The subpart to that third part, if you will, is first of all understanding what the investigatory lane of an inspector general is. It's pretty narrow, right? Again, we've touched on this before, but reprisal, restriction, fraud, waste, abuse, abuse of authority in some cases. And then most other things, the vast majority, in fact, are going to get referred back to command. So your complaint is going to likely kind of boomerang back into the chain of command. That's just how it's set up currently. And people need to understand that. And the inspector general is essentially a toothless paper tiger when it comes to accountability, redress, recourse. They don't institute any recourse, any accountability. They don't exact any punishment. That is completely in the role of the chain of command. And I think some people conflate the two there. As it relates to congressional staffers and caseworkers, we sometimes hear, well, I'm just going to get a congressional inquiry to look into my case or something kind of highfalutin, and that just is not going to happen. There are one-offs for sure.
Mhm.
There are, but Cheska, you tell me what you think. You've been shopping the lapdog report around the hill, and you've been working with congressional staffers pretty hot and heavy lately on multiple cases. Most of them, especially the caseworkers, are glorified email forwarders. They send
Mhm.
things back to the DoD, back to the department for clarification, and they accept that answer. And that's just the temperature of the water currently. So the likelihood that a member slash committee is going to intervene on the complainant's behalf is not zero, but it's incredibly low.
Well, that and one of the things that I've heard from several senator or representative staffers is when I'm presenting a case to them with one of our clients, invariably the question arises, well, have you spoken with any other members of Congress about this? And if the answer is yes, then they want to know, okay, what did those staffers say? Because they're hoping for solidarity in numbers. It seems like there's a lot of hesitation to be that first person or that
Mm,
first staffer that
hmm,
goes to their boss and says, sir, ma'am, I think we need to do something about this. But to the last theme that you just now mentioned, or trend that you just now mentioned, something that we didn't cover up front that we should have, is my mistake, is that when we talk about the relevance of evidence, I think for the majority of people in America, our concept of evidence is very much linked to what we see in Hollywood, where you have these big court cases and criminal trials and lawyers, saying, "Well, you didn't give us all the evidence, and so therefore case dismissed," or something along these lines.
mm,
But we're not in that space right now. We are
no.
talking about the administrative space
Hmm.
when we're talking about the IGs, the EO, congressionals, all this stuff. This is the administrative space. So that's one of the reasons why we wanted to do this podcast, is because the relevance of your evidence inside of the administrative space is much different than it is
Hmm.
inside of a criminal court martial, something like
Very
that.
different.
Right,
Yes.
because there's no rules of evidence
Right.
inside of the administrative space.
Yeah, exactly. There's no discovery.
Correct.
The standard of proof is preponderance of the evidence, i.e., 51%. However, as we oftentimes see, it's 51% of what an inspector assesses or doesn't, or accepts or dismisses. And there's no real check or balance, and there's no real recourse if all that evidence is not considered. So it's very loosey goosey. It does not mirror, and this is a misnomer and a misunderstanding a lot of clients have, it doesn't mirror the American system of justice in several ways, to include and especially evidentiary rules.
Exactly. Yeah, and that's again, that's why when we say the relevance of evidence, it's is it relevant?
Mm.
It's an important discussion. So
Yeah.
with that in
Yeah.
mind then, so if we're talking about, so we have something that happened, either we're the subject of an investigation or we're the complainant in an investigation or a and I think I want to start saying whistleblower instead of complainant, because that's really what you are. You're a whistleblower. So you're a
Hmm.
whistleblower because you made a complaint or you're the subject of investigation, and you have evidence either to defend yourself or to prove something happened. So how do you start? What is the first thing you need to do as you start to build your case?
The first thing you need to do is understand that evidence, whether it's considered or not, uh, in the end, is perishable.
Mm.
So, as these cases languish on, so too do memories, documents. In my personal case, one of the guiding regulations had actually been rewritten twice during the course of the glacial investigation. So, we don't want to mislead our audience by saying your 300 pages of evidence is not useful. You just shouldn't dump it on our lap when you talk to us. No, I'm just kidding. No, but you need to maintain it because it's perishable. Anything that, any rules, any regulations, witness statements, affidavits are a big one, character references, it all needs to be collected as soon as possible and nearest to the events in question, because we'll sort it out later. But to go back and to try and refresh stale memories, or to find the documents that you can't access anymore because you've PCS twice, we see
Or you've been kicked out of the building.
or you've been kicked out of the building, or you've lost your clearance,
Correct.
or
Yep.
you've been
Yep.
dismissed out of the military.
Yep.
That's all perishable stuff
Hmm.
that you can't get back. So basically the takeaway is err on the side of more evidence at the outset, and it can be whittled away. But once you've lost it, you can't get it back.
Yeah, and I think another thing that you and I have seen, and really uniformly the first question that we ask every person we engage with, whether they're a client eventually or whether we're just speaking to them as an initial consult, is what is your definition of victory?
Mm-hmm.
Because it's the same thing you do with you're planning a trip. You start with where you want to go and you plan backwards from there. And
Yeah.
so what is your definition of victory? And then take that 300 pages of evidence, we'll say, and find inside of those 300 pages or however much it is, those specific items of evidence that support you reaching your definition of victory,
Yes.
because
Yeah,
everything
that's
else
good.
is noise.
Yeah, exactly. And it kind of goes back to trend three, expectation management. If your definition of victory is vengeance, you are wrong. It's A, not going to happen, B, not sustainable, C, you're complaining for the wrong reasons. The whole point, the whole purpose of the system is to identify wrongs, to correct them such that the system, institution, organization is better. But if you're just looking to exact vengeance, you're in the wrong place.
Well, especially since, again, we're operating inside this administrative system where who does the commander work for? Or excuse me, who does the IG work for?
And only for.
The commander. I want to take vengeance against the commander. IG, help me. And the IG will be like, what? You want to do what? I don't know if we're going to do that. So then the other big thing that I've noticed is, and I didn't really realize this until I was with I think it was our one of my first clients that I was helping, is so I put together a congressional. That's great. I then say, well, now I want to use this congressional that I drafted and give it to the IG to file an IG complaint. I can't do it the exact same way every single time. So I think
Mm,
that's the other big thing, just like for any writer, any author, know your audience and write to who your intended audience is. So you have to, and there might be items, things that in that 300 pages that you included in your congressional that, uh, or excuse me, that you did not include in your congressional pieces of evidence that when you file an IG complaint, you should include in your IG complaint. So your
hmm.
evidence has to remain dynamic to not just what your concept of victory is, because as time goes on, your concept of victory might change, but also who your audience is.
Yeah, it's spot on. A lot of people have the misconception that a congressperson or staffer or caseworker kind of plays Judge Judy and decides whether an IG is doing the right thing or wrong thing based on the evidence presented. That's just not the case. They don't have the time for that. So you have to temper what you present to these parties based on what their roles and responsibilities are and are not.
Yeah. And another thing is, as someone who, of the two people in this conversation, who
Hmm.
has been on the whistleblower side and the subject side.
Could be anybody.
No, I'm talking me here. Between you and I, between you were the whistleblower, I was a whistleblower, and then the
I was
subject.
trying to keep it anonymous.
So, as part of my
A
reprisal,
retaliatory
right? A
investigation? What?
shocker, I know. So, something that I found in my investigations, in my investigation journey, as a
Of which we don't
whistleblower,
know the outcome of one still.
it's true,
X years later.
true. I have to FOIA that one. Thank you, DIA. Defense Intelligence Agency, greatest place
Yeah,
on earth.
nailed it.
Kind of like Fort Cavazos, the great place. Everyone goes, ah, no. Um, so, as a whistleblower, did my evidence matter?
Hmm.
Mm, didn't seem to. Well, it did to
Hmm.
the investigator. Investigator said, seems to me reprisal occurred, but then once it got up to the higher ups at DAIG, all of a sudden it didn't matter.
Hmm. That
Eh,
sounds familiar.
Yeah.
Hmm.
But for then investigation against me, the retaliatory investigation against me, did the evidence matter?
Hmm.
Absolutely. 100%. At least in this as insofar as the complaints were unsubstantiated because they could prove they didn't happen. So that's something else I think at least is something to consider is are you a whistleblower against the organization and the IG works for the commander?
Hmm.
Or are you under threat from the organization and you really need to get your stuff together?
Yeah, so we had a colleague actually do an informal study, if you will. It actually had to do with Defense Intelligence Agency, and I can't remember the specifics of the types of complaints they looked at, but basically they found that 100% of complaints which came from management were substantiated, and a single digit percentile percentage of complaints coming from non-management officials were substantiated within the agency. So yeah, it definitely plays. And the message here is not, or should not be, none of this matters, don't bother, right? Because as we're going to talk to maybe in a very short while here, is that the administrative process, once you go through it, it may not be the end all be all. There may
Mm-hmm.
be further steps you can take once the investigation is closed out and the report is finalized. So we don't want to sound defeatist here, but we do want to convey a realistic expectation to everyone that, for example, Cheska, how many times have we heard, I have 22 witnesses that'll corroborate my story. And in the end, none are interviewed. Oh, why not? Oh, gee
How
willikers,
did
what a
that
coinky
happen?
dink. Huh,
Yeah.
what? It happens. The system is flawed significantly and it's skewed to protect the institution. That's just a fact. But you have to go through the exercise to show you have exhausted every avenue of potential recourse before moving on to other things.
And I think that we have a statistics that's perfectly illustrative of that point. And even of my point earlier, if you're a whistleblower, does the evidence matter? Very much, maybe. If your subject, does the evidence matter? Very much so. If
Mm,
if I recall the number DoD wide substantiation of whistleblower complaints that they even investigated was
love it.
2.41%.
Love it. Yep, 2.4. That the inverse is even more dramatic, right? So it's what is that? 97.6% are liars.
Flaming liars.
Yeah.
90 over 97% of the Department of Defense with security clearances, all
Yes.
liars.
Yes, and those are just the cases investigated, not dismissed outright, aren't included in that statistic. So it's below 2%.
Yep.
Now remember, we heard the officials at the department's IG office at the head tout how well the system is working and the thousands, I think this was a quote, the
Thousands.
thousands of military members enjoying protections under whistleblower laws.
It's pretty shocking. So the last thing for today's discussion is I just want to tie back to what you were just now saying. So you've gone through the entire administrative process up to and including if some sort of derogatory paperwork is in your record and you've completed the what is it, board correction military review process for whatever the service is.
Mm-hmm.
What's next? And
Mm-hmm.
how are we shaping our organization to try to help with that?
This is exciting stuff, I think. I'll answer it first with what's not next, and that's an appeal, because
Yeah.
there is no appeal process.
Yep.
Wah wah. First of all, you got to get the report of investigation. It'll be heavily and in most cases overly redacted, and you'll get it in a matter of months, if not years. It will be veritably useless for an appeal, even if you could, which you cannot. There is an avenue to readdress your case if there's been new evidence, but again, it's kind of a fool's errand. The exciting thing we're exploring, and something I'm really jazzed about, and I don't get jazzed a lot, but I'm jazzed about this, is pursuing civil litigation against the person or persons who wronged you. And this is where that evidence that we collected, and in the timeline of events, now we're years after the fact, but it's still relevant, comes into play, because now you exit the administrative star chamber.
Star Chamber! Gold stars!
Show plug. And you enter into an actual American system of justice, like
Yep.
with courts and laws and rules and standards and stuff. And suddenly the game has changed. So that's the project we're working on. There are, of course, a myriad of laws introduced in the past by the department to insulate itself from real justice, like Ferries, Westfall, etc.,
Yep.
that we are learning to circumnavigate now and hope to explore further those routes with civil litigation in the very near future.
Which is going to be so exciting.
Game changer.
Game changer. And it's for that particular piece, for any of our listeners out there who might be looking to make some tax-deductible donations to the Walk the Talk Foundation.
Mm-hmm.
So part of our goal with our civil litigation piece of it is to offset, we haven't figured out exactly how, but to offset those costs for the service members, or currently serving and former, who want to pursue the civil litigation.
Mm-hmm.
So any tax-deductible donations, shameless plug, contact Ryan or myself, and we would be happy to help you with that cost.
to reduce your tax bracket.
To reduce your tax bracket. Very happy to help in support of veterans and currently serving military. But no, it's been a great show, Ryan. I really appreciate it. All the
Yeah.
And we'll see everyone next time.
Bye.
Bye. Well, that's it for this week's topic. We really appreciate you tuning in. Don't forget to hit that subscribe button if you haven't already, and check out our foundation website at walkthetalkfoundation.org.
And feel free to reach out and give us feedback. You can get a hold of us via Facebook, X, Instagram, LinkedIn, and our foundation's website. Details in the description section. Thanks for tuning in, and see you next episode.